Hi, everyone, and welcome. Thank you so much for joining us today to talk about the road to compliance, essentials for community colleges, and universities under the new Title IX regulations. I'm pleased to be joined by the other editors of our Title9Insights.com blog, Amy Dickerson.
Hello.
And Emily Tulloch.
Hi, everyone. So I know you all know why we're here today, which is that the U.S. Department of Education issued new Title IX regulations on May 6th. So this has been all over the news, as you can see from just a few of the headlines we have pulled together here, and as I'm sure you have been reviewing as you're doing your best to prepare your school to be in compliance by August 14th. Community colleges, and universities across the country, as we know, are scrambling to make changes required by the new rules, which again do go into effect August 14th, 2020. While you have no doubt also seen in the news that there have been legal challenges already filed against the Department of Education over these new rules, and we will certainly be following how those play out in court. But unless and until there is a clear ruling that say otherwise, institutions do need to prepare that they will have to be in compliance with the new rules by August 14th.
So we've been talking a lot about the new rules here at Franczek on our blog, which is Title9Insights.com. And we've also reviewed some of the highlights of the new rules in a previous webinar. So today our goal is not really to rehash all of the specifics of the new rules. We're going to presume everyone watching or listening has a basic level of knowledge about the new requirements. But if you really would like a refresher on the fundamentals of the new rules after our discussion today, we encourage you to check out the many materials that we've posted on our blog, which again is Title9Insights.com. And in addition to the materials on our blog, you can also use the link we've posted here, which is going to take you right to the recording of our previous webinar on the new rules. And that lays out many of those fundamentals like I talked about before. Our webinar today is also going to be recorded and posted on both our website and our Franczek YouTube channel, which includes all of our webinar content, not just Title IX related as well. So please feel free to go use those resources and share them with any of your colleagues and peers.
Yep. So our plan today is to talk about practical questions that we know many of you are having about the implementation of the rules. We know from our initial conversations with higher ed institutions and administrators that this is a daunting task and that there doesn't seem to be at times a reasonable path to get to where we need to be. But our goal today is to show you the path to follow toward compliance, a game plan, if you will, to include also a summary of the important questions that you will need to be asking within your institutions. We very much welcome your questions through the Q&A function on Zoom as we have this conversation today. Our plan is to have approximately 45 minutes of content for you today, followed by responses to any of your questions.
So before we jump into the road to compliance, we do want to go over the very high points of the new Title IX regulations, which we think will be a helpful refresher for our discussion today. So under the regs, the U.S. Department of Education set forth the new standards by which its Office for Civil Rights will investigate claims that the school did not adequately respond. And in as much as is possible, to do with 2,000 pages of regulations and commentary, we've tried to put it in a nutshell here for you. So essentially, a higher education institution can violate Title IX when there is sexual harassment occurring in the U.S. and the school has substantial control over the context of the harassment and the harasser. If an official of the school who has authority to institute corrective measures on the school's behalf has actual notice of the misconduct and the school is deliberately indifferent, which means that they are clearly unreasonable in light of the known circumstances, then OCR may find a violation under the new regulations. Now, as Emily mentioned, we covered a lot of this in detail during our May webinar, so we do encourage you to check that out if you're looking for more details for you or your team members on these elements. But we're going to address a few of the elements in a little bit more detail today since they may come up in our discussion.
Yeah, so as a quick refresher, one of the biggest changes in the new regulations is the is to narrowly define sexual harassment that is subject to the Title IX rules enforced by OCR. So the final rules define sexual harassment as conduct on the basis of sex that satisfies one or more of the following categories. And the first is where an employee of a recipient conditions an aid, service, benefit of the recipient on the individual's participation in unwelcome sexual conduct, which is otherwise known as quid pro quo sexual harassment. I'm going to quickly skip the second bullet point and move to the third. And that's where the conduct meets the definition of what are known as the big four types of sexual misconduct that are defined in the Clery Act and the Violence Against Women Act. And those terms are sexual assault, domestic violence, dating violence, and stalking. Now, this doesn't mean that those types of conduct are pulled right out of the Clery Act or VAWA. They aren't. You still have to comply with those laws as well. It just means that for the purposes of deciding whether the new Title IX rules are going to apply, you have to use the definitions of those terms as they are in the Clery Act and VAWA. And if conduct does meet those definitions, then the Title IX rules need to be followed. And then looking back at the second bullet point, if conduct is neither employee quid pro quo misconduct or conduct that falls under this Clery Act VAWA definitions, then the conduct must meet the second standard in order to be covered by Title IX. And that's conduct that we're referring to as hostile environment sexual harassment. But under these new Title IX rules, there's a new narrower definition than that which we're normally accustomed to, including under Title VII.
That's right. And we have here for you a breakdown of what is in the new definition for what we commonly refer, as Emily said, to as hostile environment sexual harassment. So under the new rules, the conduct must be unwelcome conduct that a reasonable person would find to be so severe, pervasive, and objectively offensive that it effectively denies a person's equal access to the school's education program or activity. So under OCR's previous interpretation of Title IX, schools were responsible for responding to conduct that was severe, pervasive, or persistent so as to interfere with or limit a student's ability to participate in or benefit from the services, activities, or opportunities offered by a school. And under Title VII, a severe or pervasive standard is used. So the standard under Title IX now is going to cover a fair bit less than what the rules covered before. But also, this may create some confusion in situations where there is an overlap between the Title IX regs and other legal rules, such as under Title VII. And keep in mind that just because the definition of sexual harassment under Title IX has to narrow its definition of sexual harassment under your code of conduct. Higher education institutions may still want to consider conduct that is severe, pervasive, or objectively offensive, even if not required under Title IX, or may have to, depending on state law in their jurisdictions. So for instance, in Illinois, schools are subject to the Preventing Sexual Violence in Higher Education Act, which covers some conduct that will also fall under the new Title IX definition. Processes for addressing such reports must be harmonized before the new Title IX rules go into effect, considering the various laws that your particular institution must comply with. So as we'll discuss a little bit later in the webinar, we think a goal for revising your institution's policies and procedures should be to do so in a way that complies with the new Title IX regulations, but that minimizes confusion in situations where there may be this overlap, so that your team is clear on how it will handle allegations of conduct that might not meet the definition of sexual harassment under Title IX, but that do meet the definition of prohibited conduct under other laws or your institution's policies.
Right, Amy. So one issue that we've been thinking about a lot is the overlap between Title VII and state law and these new regulations. And so conduct might be only severe or pervasive, but just because you now can't address them under your quote unquote Title IX policy, you shouldn't wash your hands of them under under Title VII or under state law. And we actually are going to be planning a blog post later this week on Title9Insights.com that's going to address some hypotheticals that we think people will find interesting in working through the Title IX and Title VII distinction.
Yep. And we think it's really important to keep all of these different issues in mind. But under Title IX, again, conduct is only considered hostile environment sexual harassment if it meets this more narrow definition that we've just gone through. And I think Jackie now is going to take us through a couple of hypothetical scenarios to flesh this out even further.
Right. So in our first hypothetical, a student and a TA, so she's a TA as well, or he or she is a TA as well, named Taylor, complains to the Title IX coordinator that an employee who is not Taylor's professor or supervisor, we'll call that person Charlie, has been engaging in sexual harassment. At the beginning of the semester, Charlie asked Taylor out while they were at an off-campus party. Taylor said no. A few weeks later, Charlie emailed Taylor a sexually charged joke. Now, this week, Charlie made a comment to Taylor while they were at a local bar that Taylor looked so hot and couldn't they just be friends with benefits? So here you're dealing with two employees, but also one of whom is a professor, one is also a student. So a lot of complications there. But the question you would be asking for Title IX purposes is this conduct severe, pervasive, and objectively offensive? And, you know, I think these decisions are going to be made on a very case-by-case basis, and we're going to need to really dig into the law. There's a lot of case law out there that has developed what this standard looks like. But I think that I tried to write a hypothetical that was a little bit on the line on purpose so that it would be not jumping out at us one way or another. I think you could make a reasonable argument both ways. But let's assume it's not. Let's assume that this doesn't follow under Title IX. Are we just going to wash our hands of this? No. First of all, we're going to have to consider the severe or pervasive standard under Title VII, and we may need to take this down the Title VII road to address whether or not that law will apply. Now, in our second hypothetical, a student and TA named Taylor complains to the Title IX coordinator that an employee, Charlie, who is Taylor's supervisor, propositioned Taylor sexually and also made racially charged statements on multiple occasions. So here, you know, one of the questions that I would have would be obviously, this seems like quid pro quo by an employee. So because of that, we would know that the Title IX process would apply. And frankly, that would be true according to the Department of Education, even if both of these, even if Taylor wasn't a student at all, if Taylor was just another employee and this exact same thing happened, assuming there were some, you know, allegations that it was going to be in return for benefits and services of the institution. But what we've added in here is there's also an element of race-based harassment. And so there's going to be a really tricky question as to what policy to use. And we're raising these hypotheticals just to be clear of how difficult these questions are going to be. It's going to be very important to make sure you have thought through these and many other scenarios as you are thinking through your road to compliance.
Yeah. And of course, just as your institutions are likely used to doing, your legal counsel, how different scenarios might play out in order to determine how best to structure your institution's policies to comply with Title IX in addition to other laws.
So what's required under the new Title IX regulations if a higher education institution knows about sexual harassment as it's now defined under the new rules? Well, it has to respond promptly and in a manner that's not deliberately indifferent. And for the first time, the rules specifically require that certain things are included in the response, including significant training requirements to ensure that the grievance process is implemented fairly and correctly, which was a really big focus in this new rule. And these are among some of the reasons that we've heard from higher ed administrators that these rules, and understandably so, are causing a lot of concern as we're approaching the effective date of August 14th pretty quickly, especially with everything else that is going on in the world right now and that our schools are dealing with. So notably also, as I know that a lot of you know, all Title IX matters must include a live hearing at the higher ed level with live cross-examination by a party's advisor. And an advisor must be provided to a party at no cost if the party doesn't have one. Now, the advisor doesn't necessarily need to be an attorney, but the rules do specify that it could be one. So that's something to keep in mind as well moving forward.
So in order to help with that work, We have put together a roadmap for you, our Title IX Road to Compliance. We will start by talking about the team that you will need to put together to address the task at hand, which is compliance between now and August 14th. We will then talk about the key roles that you will need to identify various individuals for under the new rules. We will then also discuss how you can work to get your policies and other written documentation in good shape for the August 14th implementation date. And finally, we will talk through how you can tackle the requirements for training that are required by the new rules. And as we stated earlier, we do want to leave room at the end of the presentation for any questions you may have. So again, please make sure to get those in through the Q&A function on Zoom. So let's jump right in to discuss the team members that you may want to include on your team that has responsibility for effectuating your institution's compliance. In other words, those individuals who you need to be involved or on board to get you where you want to be by August 14th. So just as we said, compliance with the new rules will require making revisions to policies, procedures, student handbooks, and website notifications, as well as training. In addition, given the various notification and meeting requirements that are spread throughout the new Title IX rules, we recommend also preparing template letters and forms to help your institution ensure compliance with these various requirements. Those of you who already have form letters as part of your processes, which I know many higher education institutions do, you may just need to be reviewing and updating your existing template letters and forms, as well as add to them as necessary. While other institutions may not yet have this as part of your process and will want to strongly consider preparing such templates to help your team be as organized and ready as possible to comply with the new requirements. So that all said, to the extent that you have not done so already, starting today, identify who are the individuals at your institution who are typically involved with these types of things, who are typically involved in revisions of those different areas, policies, procedures, website notifications, handbooks, housing all of your sample forms, as well as, who at your institution will have the information for you to help inform how those different procedures and policies should look. And make sure that those individuals are aware that you will need their assistance in the coming months. So again, the question to really ask yourself here is, who do we need to get everything done that we need to by August 14th? So when you're thinking about who needs to be on this, compliance team, your team to help you get into compliance, it's likely going to differ from institution to institution. So for instance, in a large university system, you will want to have folks involved from each campus in order to help inform how your policy and procedures should ultimately look based on the practicalities of each campus. Large or smaller institutions may have to contend with a committee system by what policies and procedures are updated. And so involvement of people who are aware of those limitations and processes, including any applicable timelines, for example, that a committee has imposed, those will also be important so that you can set your institution up to be in compliance by August 14th while meeting any internal institutional structures and requirements that you already have in place. Smaller colleges may have a more tight-knit group of officials who must be involved, which may require less coordination. However, confirming everyone is on the same page regarding the various steps required and who is needed to help effectuate those steps is something that we would still recommend. So for example, for any institution, you're going to want to have people on board who can help with logistics, such as updating your handbooks and website materials, even if they are receiving the actual language from another person or committee. So together, you're going to want to make sure that this team of individuals has the expertise necessary to make any substantive changes needed and to implement them, including through publishing the information to required constituencies under the rules and to do so within the required time frame.
So we thought it would be interesting to do a couple of polls during our presentation. So let me just walk you through very quickly how to participate. So first of all, you can do so, the easiest way I find is to do it through text. Your normal rates are going to apply for that, but you're going to text the word Franczek, F-R-A-N-C-Z-E-K, to the phone number 22333. And then when you get that response, you're going to be able to vote by just typing in the letter that's associated with the answer that you would like to provide. So you'll just put A in as the text message and hit send. If you're on a computer, you can go to pollev.com and again, enter the word Franczek, and then you'll just respond to the activity as directed. And these instructions will be on the polling slide. So I will go ahead and move there and we can do our first poll. So our poll, as we're talking about who should be the team of people that help get this done, is to find out who you are. So to ask you to describe your role for us. So Title IX coordinator is A, Title IX investigator is B, administrator student services is C, administrator HR is D, administrator business and finance is E, administrator other is F, general counsel is G, and compliance is H. And then if we didn't somehow manage to get you, you can type I for that answer. So it looks like we've got a lot of Title IX coordinators, which makes sense, some Title IX investigators, some administrators from other areas than those we've identified, and then some general counsel and legal. I'll tell you that when I created this list, I used the list of folks who had signed up for the webinar. I do know a lot of people watch our webinars after they've occurred because we do keep them all online for you. So, but when I did create this list, I had a person from each of these areas who was on there. So just a really good example of the broad range of individuals who have their toe dipped into this issue.
Yep. And, you know, these may also be a very good sampling of the types of individuals who you may, you know, want to consider cluing in and looping into this process, and consider, you know, do each of these different individuals play a role, and is it appropriate to have them be, you know, part of those involved in getting your institution into compliance. So, you know, we would say consider now giving all of, you know, the identified key players, whether it's, you know, some of these individuals here and others that you identify at your institution, you know, consider giving them a heads up now that their assistance, however large or small, may be needed in the coming months. Let them know your anticipated timeline for when they will be called upon to assist. And, you know, share your internal process and plan for compliance with them, and then provide updates or check-ins as you proceed forward. You know, this might feel a little in the weeds, but, you know, taking these steps we think can really help you and your institution get organized, let everyone know that you are on top of this and have a plan, and can put these issues on their radar to know that their assistance may be needed, and may be needed promptly when the time calls.
I think that's a really great point, Amy. And, you know, even though some of these individuals that we've listed up here, or some of the individuals that you may need assistance for, won't actually end up being those roles of Title IX coordinator or investigator, it's a really good idea to have them review the basic information about Title IX. Our blog and webinar, you know, mentioned earlier and in your slides, are two great options to go back to our blogs or some of those recorded webinars. But you know, even though they won't fulfill the technical training requirements from the regulations, the information in these materials are really essential for individuals as they work through the many questions teams are going to face as they, you know, push these changes through. So we've just talked about the team that's going to help kind of keep your train on the track, but what about the roles that are going to get your schools necessary paperwork in order and investigations completed? And those individuals fall into two types of key roles that we're going to be talking about today. And the first is those Title IX administrators, which I'm going to explain shortly. And then there's also individuals coined as officials with authority, which we're going to discuss in more detail later in the webinar. And the rules require that you designate a Title IX coordinator. While the rules don't specifically say that you need to also designate a decision maker at the appellate level, they do pretty much imply that that's the case. The rules do so by saying that you have to describe the appeal process, which probably means that you're going to have to say who at the school is designated for that appellate decision maker role, or at least how that will be determined, such as by using an appeal panel of 3 school officials who've been trained, for example. And regardless of how you identify the decision maker in your policy, you are going to need to identify who those people are internally, because they're going to need to be trained by August 14th.
Yep, and as you may already be thinking about, we would say to consider also identifying alternates to these individuals, so that if the individual who you primarily plan to have fill a certain role is unavailable or has a conflict, you will have others who have been trained and can step up to fill these roles if needed.
And once you've identified your team for making changes, the first step we recommend that you do is identify the individuals who are going to be necessary to implement these rules themselves, which we're going to refer to as your Title IX administrators. And first, we have the Title IX coordinator. So designating a Title IX coordinator is nothing new. What is new is that they have to be specifically called the Title IX coordinator in their title and in your policies. Do note that you're still able to designate deputies and even multiple Title IX coordinators. It might be a good idea to identify an individual with responsibilities in student services, someone in human resources, and someone from athletics as deputies, so that you can really cover all of your bases. But ideally, your Title IX coordinator is going to be someone who can oversee all of what Title IX covers. And remember too, for anyone who may be new to the Title IX coordinator role, the 2015 Title IX resource guide is still in effect and is a really great resource that kind of takes a deep dive into all the facets of the role.
Yep, and again, that resource guide covers all of the areas under Title IX with which a school must comply, not just sexual harassment, which is the focus of the new rules. So that is certainly a resource guide that if you're not already familiar with and you're stepping into or have been in the role of the Title IX coordinator, we would recommend being familiar with that as well.
And one thing that we have heard asked is whether you need to designate multiple Title IX coordinators. If you're a large university system, we actually have long recommended that you consider having someone at the system-wide level as the Title IX coordinator. And you used to be required to have a Title IX coordinator, but a lot of folks would have a Title IX coordinator at each individual campus, for instance. But when we've conducted audits for university systems, we've seen issues of consistency across campuses are very common. And so this is really a great opportunity to reformulate your system to address those types of issues. It doesn't have to be that the Title IX coordinator position is a terribly burdensome role, because if you remember, the commentary to the rules say that your Title IX coordinator can delegate tasks as long as the recipient is getting what is done as required. So system-wide Title IX coordinator might not be the one having that initial meeting with a complainant, for instance. They might delegate that to a Title IX coordinator at the campus level, or a deputy Title IX coordinator may be doing it. You just want to make sure that your policies actually reflect what your practice is and give the right to delegate if you're going to be relying on it.
Moving on from Title IX coordinators, we also have investigators. So these individuals are going to need to be very familiar with the investigation requirements outlined in the new rule, including evidentiary issues such as relevancy, report requirements, and requirements for sharing evidence with both parties before a final report is issued, just to name a few. And that means that your investigators should really be people that you trust to fulfill these really detailed requirements. Do note as well that your investigator can be your Title IX coordinator, and this may be particularly helpful for smaller colleges because it really narrows the number of administrators you're going to need to fill all of these different roles. We also do still recommend that you have an investigator available of each sex to address situations where a request by a party for an investigator of one sex can be met then. And that'll be easier for larger colleges and universities. We understand that, where you already are having multiple investigators trained at each campus to keep open the option to have those like building level investigations.
Yeah, and on the sex issue, it may not always be possible because, as we now know under these rules, the rights have to be given equally to the complainant and the respondent. And so what happens if both of them want a Title IX coordinator that's of their same sex? Obviously, you're not going to be able to pull that off. So, we'll just have to work through what that looks like. But also note that the investigator doesn't have to be the Title IX coordinator. So you could use this as a chance to streamline your practices. So under our previous iterations of Title IX as interpreted by the guidance, a lot of times, even though our deans of students might be the best investigators we have and the ones who are the most connected with the students, we've often relied on separate Title IX offices to handle the investigations. And that really made sense under our old model. But this might be a chance to, again, kind of streamline these processes. And we're already going to have to be dealing with the fact that someone is going to be investigating complaints of sexual misconduct that don't rise to the level of sexual harassment under these rules. And so, you know, again, think about how you can, where you can house investigators and where you can pull investigators from to best meet your campus's actual environment.
That's a great point, Jackie. Moving on to decision makers at the complaint level, you know, where you can double up, like we said before, and have your Title IX coordinator also play that investigator role. When it comes to decision makers at the complaint level, these individuals cannot be your Title IX coordinator or an investigator. So your decision makers have to be able to make determinations regarding responsibility by applying those evidentiary standards that your institution lays out in its grievance process for formal complaints of sexual harassment. And the rules also really emphasize that decision makers have to be free from bias or conflicts of interest against complainants and respondents generally, or against any individual complainant or respondent, which again was a big focus of this new rule. And they also require training for decision makers on how to perform those roles impartially.
And remember that your decision maker must use a live hearing with all the bells and whistles required by Title IX. These are much more structured, almost pseudo-judicial proceedings. So think carefully about who you are going to want to identify for this type of decision.
And, you know, to the extent that you do or would prefer to use a panel model, whether it's a, you know, for a hearing panel or appeal panel, you know, we think you can still do that. There doesn't seem to be any prohibition in the rules, you know, to have that panel model, or even frankly to bifurcate a decision maker role in terms of a decision maker for deciding responsibility and then one who decides sanctions. But what is very clear is that, you know, neither of those can be the Title IX coordinator or the investigator. So that's the primary takeaway, is that, you know, we really moved away from, you know, schools being permitted to have a single investigator decision maker model if that was the model that you did have.
Yeah, and similar to these other decision makers, at the appeal level, these individuals cannot, again, be your Title IX coordinator, your investigator, and they can't be those decision makers at the complaint level. So keep in mind that all decision makers also must be trained on topics required in the new regulations as well.
Yeah, Emily, and one thing that I think people need to keep in mind relates to the use of legal counsel for these types of roles. We know you're all already adept at striking the balance between having legal counsel guide you on Title IX issues, but also being open to defend you if a lawsuit or other challenge arises. And those walls do continue to be important, but the judicial nature of these processes, especially at the appeal level, where you're really dealing with some very, you know, typical legal analysis and issues, really screams for having someone with knowledge of legal processes, or at least having someone on the line who can help guide them through those types of decisions.
And we know that some of your institutions are very experienced now with handling appeals and applying your policy definitions and standards to those appeal decisions, as well as with handling investigations. But utilizing outside resources, including attorneys, you know, with the appropriate training to help fill these roles, may be an option that schools wish to consider, either on a case-by-case basis or as part of your institution's procedures, even if not expressly identified in your policies.
So rounding out some of the key roles are informal resolution facilitators, who will be responsible for, you know, as their name suggests, facilitating resolutions between the parties. And remember, under the new rules, an informal resolution process can only be used if a formal complaint has been filed, and it can't be used in cases where employee on student sexual misconduct is involved. And these individuals cannot be Title IX coordinators, investigators, or decision makers. But they are required under the new rule to have the same anti-bias, anti-conflict of interest, and other training requirements.
Yeah, and even in addition to those training requirements, so when I was at OCR, I actually did the facilitated resolution between the parties, or it was initially called ECR, the early complaint resolution process, which actually is a very nice template for what this informal resolution process should look like. And, a couple of things that I learned from that, one of them is that even though it doesn't require, there's no requirement in the rules for training on how to do informal resolutions or facilitate mediations, that, there are a lot of very tricky elements to that. And so you are going to want to have some practical hands-on training for these people, just to be able to work through those nuances of how to do those informal resolutions. And then also keep in mind, if you have a group of investigators that you've identified, just because the investigator on a particular matter can't do the informal resolution doesn't mean that a investigator on any matter can't do it. So, I wouldn't do informal resolution for my own cases when I was at OCR, but I regularly was called on to do them for another investigative team where I was walled off from it. So definitely remember that at least for those of you that are large enough to be able to identify a number of investigators, that you can double dip in a way in that fashion.
And also keep in mind that although this is informal, there are now rules on what is required for the informal resolution process, including providing the parties with a particular type of notice regarding the informal resolution process. So whether, the parties or institution are electing to use something like a mediation or something short of that, there are particular requirements that schools must meet in order to use the informal resolution process that may differ from how your institutions have utilized it in the past.
And then keep in mind that, as Amy mentioned earlier, you can rely on outside resources for a lot of these elements. So for instance, if for investigators, you may have a large group of investigators, but for one reason or another, you may have conflicts of interest or concerns about appearance of bias or impropriety that limits your investigators being involved in a particular case. Or you may not be able to get everybody trained by August 14th. We know that that's something that people are really thinking about as a serious concern. If those types of things happen, you can call on outside investigators, as we know many of you have done in the past. And we here at Franczek will have investigators trained and ready to go on August 14th if that's needed. Same thing with appellate decisions and informal resolution facilitators. Those types of things, they can be farmed out again if you need external and outside resources. And you will be able to find more information about our thoughts on those issues, as well as information about training and forms and all sorts of other things on our Title IX Toolkit webpage that's going to be going live this week, which we've got the link there for you.
So now that we have talked about the Title IX administrators, let's discuss officials with authority. So under the current Title IX rules and guidance, OCR has used the term responsible employees to describe those individuals whose notice or knowledge of alleged sexual harassment would trigger an institution's duty to respond. Now, under the new rules, instead of using the term responsible employee, the new rules and comments to the new rules refer to those individuals whose notice or knowledge triggers an institution's obligation to respond as officials with authority. So for all institutions, notice to the school's Title IX coordinator or to any official of the recipient who has authority to institute corrective measures on behalf of the school, which are referred to as officials with authority, that conveys actual knowledge and triggers a school's obligation to respond. So note, for elementary and secondary schools, notice to any employee, in addition to the Title IX coordinator or to any official with authority, triggers the school's response obligations. But that is not true for higher education institutions. So this change can lead to a much narrower subset of individuals whose knowledge will be imputed to the institution. The comments to the rules note that this approach was adopted to allow higher education institutions to decide which of the employees must may or must only with the student's consent report sexual harassment to the Title IX coordinator. The comments note too that the department believes that students at higher education institutions benefit from retaining control over whether and when the complainant wants the school to respond to the sexual harassment that the complainant experienced. The comments to the rules also state that determining whether an individual is an official with authority is a legal determination that depends on the specific facts relating to a school's administrative structure and the roles and duties held by officials in the school's own operations. They also note, however, that higher ed institutions ultimately decide which officials to authorize which officials to authorize to institute corrective measures on behalf of the school. So to make this clear, schools should consider expressly identifying these individuals in their policy. And as the comments explain, notice results when any Title IX coordinator or any official with authority witnesses sexual harassment, hears about sexual harassment or sexual harassment allegations from a complainant, who is the person alleged to be the victim, or a third party, or if they receive a written or verbal complaint about sexual harassment or sexual harassment allegations, or by any other means, as the comments say. So at that point, the Title IX coordinator or designee's obligation to at least communicate with the complainant to offer supportive measures and explain the formal complaint process kicks in. So remember, as the commentary explains, a higher education institution can decide which of their employees must, may, or must only with the student's consent report sexual harassment to the school's Title IX coordinator, a report to whom would always then trigger the school's response obligations, no matter who makes the report.
Right, Amy. And then one question we've received has been whether institutions should keep all of their responsible employees, require them to continue notifying the Title IX coordinator in any case where they learn of sexual harassment. And you can, it may be warranted based on your culture and climate at your institution. But what we're concerned about is that you will be increasing the number of complaints that are having to be addressed under this new, very burdensome and specific Title IX process. And that's not necessarily a bad thing, but we just want you to be aware of the impact on resources. Also, you know, the regs do, the commentary puts a really high priority on confidentiality. And I know that when I was at OCR, I had many institutions that reported that they were concerned that under the old rule, people weren't feeling comfortable reporting sexual harassment because they knew that if they reported it to almost anyone, that it would end up in a formal investigation. And that has now been changed. And I do encourage you to really consider, based on your culture, your climate, your institution, whether that's the right move.
Yeah, and I just underscore that I think that decision would really have to be made, really taking the pulse of your culture and climate and where you've come already over the last several years in developing what I'm sure are very institutionalized processes that you have now, and what feels like the right next step now, you know, for your school under these rules. So, you know, then actual knowledge is, you know, now really the new standard as well under the Title IX rules. And so we have the actual knowledge standard comparison for you, you know, to have here in visual form. The key here is that because the institution is responsible for the actual knowledge of all of its officials with authority, as well as your Title IX coordinator, it's extremely important that those employees who are officials with authority know that, and know what type of conduct or communication might trigger this responsibility, and know who to report such conduct or communication to, so that they can report that to the Title IX coordinator then when needed. And for your community, even though we don't see explicitly in the regulations that you must identify the specific employees in writing anywhere, it appears from, you know, the over 2,000 page comment section, you know, while we haven't memorized it yet, you know, we do feel that those comments, that the spirit of those comments do encourage schools to do whatever you need to do to make sure that your officials with authority not only know who they are, but that your community knows who they are too. And the best way to do that may be to include them, even if by title, in your policy, as I think many of you already do.
Right, and remember that even though a formal complaint is now what triggers the school's obligation to investigate, once an official with authority has actual knowledge of sexual harassment, that also is going to trigger the overall Title IX process. So that includes the initial meeting with the alleged complainant to let them know of their rights under the policy, their ability to file a formal complaint, and any supportive measures that may be available, whether or not a formal complaint ends up being filed.
Okay, so let's switch gears for a moment and talk about policy, because I know that many of you are already working through what is your policy going to look like under these new regulations, and that there may be a lot of questions. So I would say that the biggest issue that has been raised that I've heard so far is the decision about one policy or two. A related issue is, do we extend the scope of the Title IX regulations to other types of sexual misconduct that's not exactly required by the Title IX regs? I already sort of talked about that second prong, which is that, really to think about the resources that would require, and also to remember that you do technically have to dismiss anything that doesn't fall under Title IX regs definitions for sexual harassment, even if you do choose to go on and use the same procedures for other conduct. Now, with respect to the one policy or two question, I think the biggest thing is that there's really not going to be a one-size-fits-all approach. I believe our current thought is that whether you have a separate policy or you just have a separate track within your more broad, uniform sexual harassment policy, that these rules will be very hard to apply without some kind of clear segregation of the processes themselves that are required for Title IX and those that aren't required, or those that require a different, lesser process. And I've been referring to the one policy approach as a choose your own adventure approach. Those were like my favorite books when I was a kid. And you may recall that you make a decision at one point and that determines which page you turn to in the book and how your story continues. And so even if you're putting these into one policy, unless you're going to use the Title IX regs for all sexual harassment complaints, including employees, non-employees, everybody, and just the only difference is that you're going to have a formal dismissal under Title IX if it doesn't fit the actual definitions of the regs, then you are going to have a place where there's a fork in the road and you move into the Title IX reg processes, whether or not that's in a completely separate policy or it's just another track under one policy. Because the regs do require that the processes be addressed somewhere in the policies, and there's a number of things that have to specifically be in there, they're going to have to be in the policy somewhere. And so for those of you who end up deciding to purchase our Title IX toolkit, which will be available soon on our website, I did get a question if we would reshare that link. It will definitely be in the materials that you receive after the website, and we'll also send you another alert when that information is live. So you'll see there our thoughts on what the policies have to include, but also should include in order to protect against mishandling by your administrators of these very unwieldy and sometimes confusing processes. So as we've mentioned, we don't necessarily recommend that you use the Title IX procedures for all of those matters that don't apply, but if you do, if there are unique circumstances in your community that require it, I would just recommend that you're talking to your legal counsel before you're making that decision. Of course, other changes will need to be made to all policies and procedures that address sexual harassment to ensure that they align with the Title IX regulations. So sometimes our sexual harassment procedures refer to Title IX in more general policy language that you may still want to apply to other types of sexual harassment or sexual misconduct. So we just want to make sure that we're not limiting that to just Title IX anymore. And no matter how you design your policies and procedures, the biggest change from these rules is going to be what happens behind the scenes with the Title IX coordinator or their designee, and ensuring that they are providing those required notices and documents and letters and actions and forms that are required. And so again, that's why we're putting together a toolkit that will hopefully be able to make sure that they're able to check off all of those requirements, which will be almost as important as what's in the policy.
Now, Jackie, I know we've heard from some clients some concerns about meeting the deadline for August 14th when it comes to having their policy completely updated and revised by that date. And obviously, as everyone's heard throughout the webinar today, you know, we're talking about getting, you know, you into compliance as much as possible and as best as possible by that date. But do you have any insights, having been at OCR, as to you know, insights to offer any schools who feel like, you know, it may be difficult to meet that exact August 14th deadline, which hopefully they will, but any insights if they don't? Oh, I think.
In my experience at OCR, I think, you know, particularly in cases which a lot of times it would happen where OCR would find that there was insufficient evidence that there was any policy violation with respect to like a particular complainant or a particular respondent, but that there was something missing from the policies or the handbooks. I was actually very impressed when I was there with the flexibility that we would get, at least from within the Chicago office, or that we would give within the Chicago office, to allow institutions the time to reasonably update and make those changes. Now, I know that they've come out and said that they think 100 days is more than enough time for us to all digest all of this and get it all into paperwork. And I do, you know, encourage you all to really work your best to get your policies finalized. But particularly if there's not a particular complainant or respondent who's saying my rights have been violated because they didn't follow the new rules. Let's say you just get a complaint from an organization that says, hey, your policies aren't all done, or, you know, your training hasn't all been done. I think that that you might be able to get some flexibility from OCR.
Yeah, and certainly if any institutions find themselves in a bind, you know, hopefully you're working then and do work with your legal counsel to help assist with getting into compliance and then with navigating any complaints that arise before then. But again, we want to do what we can to meet and meet that deadline by August 14th. So with that said, another thing that you want to do your best to get into you know, compliance with by August 14th is the training requirements. And so the rules do contain express requirements for training that different parties must have, which again must be done by August 14th. And each individual who is required to be trained under the new rules must be trained before they carry out that role under the school's policies and procedures. Now note that, you know, our team here at Franczek will be trained by August 14th, as Jackie referenced earlier, to assist with investigations and appeals and informal resolutions of complaints as needed, either as a stopgap or in situations in which concerns with bias, conflict of interest, or practical concerns warrant having an outsider step into help. But with that, let's walk through what the training is required and how you can get it done by August 14th. So for coordinators, investigators, decision makers, and informal resolution facilitators, and that's any person who may be designated to facilitate an informal resolution, those individuals need to be trained on the definition of sexual harassment, the scope of the recipient's education program or activity, how to conduct an investigation and grievance procedures, and how to serve impartially, including by avoiding prejudgment, conflicts of interest, and bias. All those that are designated as decision makers need to also be trained on any technology to be used at a live hearing, as well as on issues of relevance of questions and evidence, including when questions and evidence about the complainant's sexual predisposition or prior sexual behavior are not relevant. Investigators must be trained on issues of relevance to create an investigation report that fairly summarizes relevant evidence. So we are providing a training that can be tailored to your institution, including providing that training via Zoom this summer if you are looking for a way to get this done. And that training will incorporate the required elements for the trainings that are expressly identified in the rules, as well as best practices that we recommend.
That's right. And then we are also doing a similar thing with respect to the other type of training, which is a different training that's required, or actually I should say it's not required by the regs, but it's required by me and probably by any other lawyer you would talk to who represents higher ed institutions. And that is the training for your officials with authority and your Title IX coordinator to be able to identify sexual harassment and to report that to the Title IX coordinator. Now, we know that you might be considering of having your Title IX coordinator do that training, and that's great, but they are required to go through the training as well because they are officials with authority. So it either needs to be woven into the Title IX coordinator training, which we are planning to do, or you need to have some kind of train-the-trainer training, or have them sit through the training that you're going to provide to those individuals that you identify as officials with authority. So with that, we do have a couple of questions. So one of them was, at what point does an investigator need to find another investigator or employee to facilitate an informal resolution process for the parties? So, you know, I don't actually know, and I apologize, Amy mentioned we've, you know, been drowning in these regs, and I'm not sure there's a specific requirement in the regs that says that you need to have the informal resolution person be separate, but it is so second nature to me from my time working at OCR, and the regs do say that the person needs to be unbiased and without conflict of interest. I would find it very difficult to be the same person tasked to do informal resolution, where if you think about it, people talk about all sorts of things that, you know, they might not necessarily share in a more formal hearing. And I just find that it would be very difficult to actually pull off having the same person do it. I don't know, Amy or Emily, if you have thoughts on that.
Yeah, I mean, I think that's right. The regs, you know, talk about, you know, having a person who's designated to facilitate informal resolutions, but, you know, as I see it as well, does not specify that it has to be, you know, someone different. And so, you know, I think schools have this flexibility and may, you know, could consider this depending upon what they anticipate the informal resolution in a particular circumstance being and how involved it is. But, you know, keep in mind, we talked about that, you know, to now use the informal resolution process, there are certain things that are required, which includes a notice to the parties that include that at any time prior to agreeing to a resolution in the informal resolution process, any party has the right to withdraw from the informal resolution process and resume the grievance process with respect to the formal complaint. So especially if there is going to be a lot of contemplated back and forth that may occur through an informal resolution process that's being facilitated, you could certainly anticipate that if there are things that are shared or going back and forth through that process like Jackie described, and then that process isn't ultimately successful and you go back to having someone investigate, you could certainly, I think, anticipate that in certain scenarios it may then be, you know, more appropriate to have different people filling those roles. So that's something to consider as you're moving through this process. And at a minimum, I think, consider who you want to have right now be part of your training to be on board for filling these roles, even if you end up just having, you know, different individuals fill them on a case-by-case basis.
Right. And I mean, I'll just tell you that my new favorite thing since coming back from OCR, when I'm doing a defense of a client and they have done something that I know from my intimate experience that OCR does the same thing, is to throw it back at them, because it's very hard for them to say that if you're following the same processes that they're using, that you are doing something wrong. And so, for instance, even though now you're sort of required to provide under the regs a letter of notification, OCR has always done that. And so I've long told my clients that they should consider doing that even before it was required, and to include the allegations and any allegations that were decided not to be opened. Because again, if OCR came along, I would be able to say, well, we did the exact same thing that you do in your investigation, so therefore that it must be perfect, right? So another question that we received actually through the registration process, which thank you for it, was you know, wanting a little bit more information on what you're limited in doing if an individual doesn't show up for a hearing or chooses not to participate in the hearing process. So this is an example of, like, for example, you've got a bunch of students who report to you that something happened, you've got corroborating witnesses, you know, you're ready to go, and then the hearing comes and they don't show. And the rules say now that you cannot rely on statements that were made outside of the hearing process when reaching the decision. And so the question was focused on, are we able to use other documentary evidence? So let's say there was something that was on Facebook that was a public post, or you know, other things like that. Are we allowed to use those? I'll just say from my perspective, then I'll open it up to Amy and Emily, that I think it's a gray area, but I think what I do know is that you are going to look for other evidence, and that in many cases, you know, we've long been prosecuting, you know, I call it prosecuting, but we've long been bringing these cases and asking for findings of responsibility against respondents, even in situations where we didn't have a willing complainant, because under the old rules, you know, we had this should have known requirement. So, you know, I think, yes, there's this weird evidentiary rule that doesn't exist basically anywhere else. I mean, there's even hearsay exceptions in court, but, you know, this new rule applies, and it does limit you relying on their statements. Now, whether that means their statements to you, the Title IX coordinator, or their statements that were made online, I think we'll have some room to argue both ways.
Yeah, and I think this is a great example of one of the areas that, you know, where there are gray areas in these rules, and there's many for sure, and something that we'll want to continue to think through these types of scenarios and how they may play out, either as much as we can do proactively, as well as then, you know, of course, relying on legal counsel when certain situations arise in the moment to help you navigate, you know, what, for example, in this scenario, what you can and can't rely on depending upon the circumstances.
So I know that we're a couple of minutes over time, but we do have a couple of questions. So we're going to keep going. And again, if you need to drop off, this will be recorded. It'll be sent. Please share it with your teams, and feel free to catch up with any questions you missed on whatever time works for you. So our next question was, can you speak to the new record retention and publication requirements, especially where training is concerned? Amy, I know you've thought a lot about the record retention stuff because you and I have talked about it. So I don't know if you want to take a stab at that one.
Yeah, and I'll confess I've got the regs pulled up here, so I'm not going to totally be speaking from memory. But in terms of record keeping, there is the requirement now that schools for a period of 7 years must maintain records of, you know, what I think of essentially as your investigative file. So the language is you have to keep records of each sexual harassment investigation, including any determination regarding responsibility and any audio or audiovisual recording or transcript of a hearing, any disciplinary sanctions imposed on the respondent, and any remedies provided to the complainant designed to restore or preserve equal access to the school's education program or activity. In addition, what must be maintained are records of any appeal and the result therefrom, as well as any informal resolution and the result therefrom, as well as all materials used to train Title IX coordinators, investigators, decision makers, and any person who facilitates an informal resolution process. Then the regs go on to say that a school must make these training materials publicly available on its website, or if a school doesn't maintain a website, then the school must make them available upon request for inspection by members of the public.
Yeah, so I have a lot of thoughts about that. You know, for those of you who follow this stuff as much as I do, which is sort of embarrassing to admit, but you have probably been aware of the back and forth that happened between ATICSA and OCR. We actually did a blog on our Title IX Insights website about that if you want the backstory. But, you know, essentially, initially, ATICSA and some other folks had said, hey, this is our copyrighted material. You can't make us put it up on the web. And OCR came out and very unequivocally said, well, we can't make you, but we can make these institutions find someone who will let them. So I know that now ATICSA has stepped back on that, and they've said that they will be making their things available. We are going to be making it very easy for the institutions that choose to use us for training to include a link that has information that we will host on our website where the training materials will be available. And I'm very excited to say that we are going to hopefully be putting up a video podcast on our blog in the coming week or so with a local copyright attorney who is willing to speak with me about some of the copyright considerations that I know institutions may not necessarily be that familiar with, but that are going to come into play with how they share and use these materials. So definitely keep an eye on our blog for that in the coming weeks.
And one other just record keeping thing to note, and I think this is one of those things where having a sort of form or something could help you to keep organized, is that schools must also create and maintain for 7 years records of any action, including any supportive measures, taken in response to a report or formal complaint of sexual harassment. And in each instance, the school must document the basis for its conclusion that its response was not deliberately indifferent and document that it's taken measures designed to restore or preserve equal access to the school's program or activity. And if a school does not provide a complainant with supportive measures, then it must document the reasons for why such a response was not clearly unreasonable in light of the known circumstances. And the documentation must all of certain bases or measures, the regs say, doesn't limit the school in the future from providing additional explanations or detailing additional measures taken, which I think is sort of a flag that, if you have to give additional explanation to OCR, perhaps, if a complaint is filed, you're able to do that. But there is that additional record keeping requirement that I think would be, really helpful to kind of develop a form template for your use to make sure that you're meeting that requirement as well.
Well, thank you so much, everyone, for joining us today. We are so grateful to get to work with some of the best higher education institutions out there, and we appreciate always from our clients and friends when you join us for these types of events. We've got our contact information up here as well as our blog. Please check us out, and if you ever have questions, please don't hesitate to reach out to any one of us. Thank you so much for joining us, and we hope you have a wonderful day.
Bye.